Good afternoon or good morning, as the case may be, wherever you are listening to from me. I am in India, as you all know, and I have been wandering in the realm of knowledge for the last 41 years because I've been very badly injured physically, emotionally, in every way possible because of the tactics employed by one of the largest corporations in America, namely AT&T. They are a monopolist corporation at the time when I was working for them, and later on the U.S. Department of Justice wanted to break them up. So the U.S. Department of Justice had a case against them going on for about 15 years. It is at that time I was sent to work for them from a company called Michigan Bell Telephone Company. Yes, you see them in the videos. What happened was, I'm only rehashing the story, which those who have heard me or will be hearing me knew. When I was working for this company in Orlando, Florida, Monday morning, I got a merit increase of $5,000, and a fully satisfactory job performance rating. And on Friday, I was dismissed from my job. Folks, you have to hear this. There is no reason at all. I came to know a couple of years ago, there was a reason. I was researching, and that reason was President Reagan in the year 1980 stood for election as the President of the United States, and one person who was a Catholic priest, he later became not a priest, he became a businessman. He contributed to President Reagan's election coffers $600,000. Whether that contribution, political contribution, met the requirements of the law, I do not know. I'm not going into that. I only mentioned he paid President Reagan $600,000, and President Reagan, not knowing this guy is a mafia who belongs to the Genovese crime family, he touted for this guy to be his Secretary of Labor. The Senate approved him with an overwhelming majority. You can see, those who have access to C-SPAN, that's about 2 hours Senate proceedings. There was also, my research showed, 901 pages of the FBI report for and against Donovan. James Donovan. Now, James Donovan, when he was elected and President Reagan appointed him as the Secretary of Labor, he wanted to abolish all the laws, namely OSHA, Occupational Safety and Hazardous Act, and ERISA, Employees Retirement Income Security Act, want to reduce the force in the Labor Department who enforces the laws. And the person or the entity who benefited most was AT&T. So my research further indicated during the period I was terminated illegally, Michigan Bell, where I was working previously, and I was on a contract to work for AT&T for a period of 5 years. They were laying off their own people, thousands of them, thousands. And Michigan Bell, they call Ma Bell affectionately, they were indiscriminately firing their employees, but they offered them benefits like medical coverage for the employees. They paid them severance pay. Okay? I didn't know any of the things until I researched a couple of years ago. Okay? I was fired in 81. It is the same time they were getting rid of their people. I didn't know about it. And they treated their employees differently. Gave some people 1 year's salary as additional compensation, which was denied to the others. So there was a class action in the Michigan court, state court. Judge Pratt had written an opinion. He disallowed those people who were not happy, appealed the court's decision to the United States Court of Appeal, which reversed the decision, which I didn't know until year before last. Okay? That's the fruits of my research. Now I knew why I was fired in the invited presence of my wife. At the time, as you see, I had 4 children, aged 3, 7, 9, and 12. My dependent father who came from India to enjoy the American way of life, and my dependent wife who was professionally a nurse, registered nurse, taking care of the small children. Folks, to cut the long story short, this mafia corporation held me and my family to economic ransom and blackmail until I was forced to sign a release. That's the only issue before the court, whether that release, which I signed, a 2-page release, is it valid under the standards set by the U.S. Supreme Court in a case called Alexander versus Gardner, Denver. That case was decided in 1973. The holding of the Supreme Court, an employer can obtain a release from an employee provided, these are 3 phrases, the employee gave the release freely, voluntarily, and knowingly. You understand, folks? So, that issue, the judge realized is not going to fly. The company wanted to get rid of the case without a hearing and a trial. You understand the name of the game here? The U.S. laws do not permit them to terminate an employee without a just cause. There was no just cause because I got a merit increase on Monday morning and a fully satisfactory job performance. And we were all wondering why I was terminated in the invited presence of my wife at a hotel in Disney World. Disney World is about 10 miles from my home in Orlando, Florida. There is on Disneyland, that is in California. Okay, so Disney World and Disneyland. We are talking Disney World in Florida. So, to cut the long story short, the defendant failed to prove their burden. What they did, as I told you before, they attempted to bribe my lawyer, Surya Kapil. He is a well-known lawyer from Kerala. He was practicing in Chicago. First, they offered him to be a judge in Cook County. I'm the one who answered the phone because he was on another phone. I picked up. He told me to pick up. And I handed over to him. He said, I heard him say 3 times, not interested, and he hung up. Then this sucker company offered him to handle cases on their behalf. Why? Because they knew he is a strong lawyer. He's the one who argued the case of Morarji Desai, Indian Prime Minister, who was allegedly a CIA informant. That's the allegation against Morarji Desai. So there was a defamation case going on. So I am only saying the background. My counsel was eventually murdered. I can't link because I didn't know his murder for about 5 years. I was living in New York, he's in Chicago. You know, we don't have time to watch Chicago news. So when I came to know it was too late, and it appears the person who killed him was another Indian client. That's the news, we don't know. Now, this Judge Reed, he knew the problem, the canons of ethics, professional responsibility. He was meeting his former law clerk, this slut. Her name is Anne C. Conway. She was then 31 years old. I researched everything. I spent so much time researching last 41 years. So, in addition to meeting him in the court, in his private chambers, why he wanted to meet me in his chambers rather than in the open court? Because the other attorneys who are practicing in that court knows this woman was his former law clerk. That refusal to disclose that and conducting the proceedings is a violation of the canons. Now, to add further insult, this woman was going to the judge's home to give him what we call TLC, tender loving care, or sex, okay? And possibly bribe him, because judges made in those days 72,000 a year salary. So the corporation thought, rather than paying me X amount of money, they can have this girl do the work for him. So they were meeting each other's homes, which I told you before, which is a flagrant violation of the canons of ethics of the American bar and also the violation of the Florida law. I made a complaint against both of them, and what happened was Judge Reed had to finally admit his association with this woman, meeting her at his home, her home. I notified the FBI and Chief Justice at that time, Warren Burger. He was a very honest man. Lawyers don't like him because he is doing his job. He ordered Judge Reed to recuse and resign, which he did. Folks, when a judge recuses and resigns for a cause, he has no authority to pick who the case should go to. There were 6 other judges in Orlando at that time. I have the names. That's not the point. But Judge Reed doesn't want to give the case to one of the judges in the same court. There are 6 district court judges. Okay? He wanted to have the case sent to his buddy, which is defendant AT&T's chosen successor. You understand? Now the legal problem is, when the court has no jurisdiction, that court cannot decide the case. That's a well-settled rule of law. If the court has no jurisdiction, it can't decide. This guy, Hodges, sent me an order to New York, directing me to come to his court. I went there in good faith because it being a court's order. I didn't know at the time the hanky-panky going on. This guy says, I've been appointed by Judge Reed, the outgoing judge. This case is mine from now on. I rose to make an objection, what's it called? We call instander, a motion to disqualify. He said, no, I also made a motion in writing, black and white. He refused. Okay, so he was having the case by force. A court has no jurisdiction, lack of jurisdiction, it can't decide the case. That's the law of the land. Okay, and if any judgment rendered by that court is a legal nullity, void, null and void. Now, he won't conduct the proceedings. You have to understand the name of the game. The rules require a judge to decide a case within 3 years, federal rules. He won't do anything. 82 filed a case, 82, 83, 84, 85. 4 years passed. So instead of deciding the case based on my statutory claims, the statutory claims I raised, and my counsel, Shreya Kapil, was violation of the ADA claims, Title VII of the Civil Rights Act, ERISA claims, and breaches. So that case was never decided by Judge Reed's chosen successor, Hodges. They kept the case in a state of suspended animation and invented a case law. You understand the tricks here? They created a case by dismissing another employee by the name Orville E. McDonald. He was a division manager working for AT&T. They fired him like the way I was fired. They gave him $12,000. So the Michigan court, state court, held in a per curiam unpublished order, McDonald must refund the money to the employer. See the tricks they are deploying? Issue before the court is the validity of the release. They don't want to try that. They gave up. They have not filed a defense as to whether you should tender back the money. That's the argument they are advanced. And they got a what you call per curiam unpublished order. That order was overthrown by the highest state court. I got a copy of that only a few days ago, because in the process of my searching for truth, 3-judge panel denied their appeal, okay, and they were allowed to appeal if they want to. Okay, we will show you a copy of that. These are things which I didn't know. They knew when they were filing that case. Now, you got to understand the name of the game here. Now, every court that I researched, the clerk of the court is the intermediary through whom they accomplish their mission. How they do it? They pick the clerk of their choice as a clerk or a deputy clerk, okay? Because these are predetermined game plan. Every court in the United States may be an exception here and there, but every court that I researched, same game plan. So once they pick the clerk of the court or his deputies, the scheme is major corporation cases go to the judge of their choice or judges. Unlike here in India, we have one district judge or two in a court, in a district. In America, we got too many, around 1,600 district judges. Okay, so it's easy to pick through the clerk of the court which judge a corporation wants, because the corporation is researching which judge will decide in their favor. I have read extensively. There are books written, volumes written, articles written about the case-fixing games. So, this judge, Hodges, without conducting any hearing whatsoever, no hearing, no trial, no discovery, issues an order. Where does he get the facts for his decision? He is a magician. He gets the facts from his hat. Although I appeared before him only maybe 10 minutes. Okay? So he writes an extensive story, 5 pages. You will see a copy of his order. And he says in the concluding paragraph, the case is dismissed without prejudice. Mark the word. Without prejudice, unless Mr. David returned the money paid him, which was paid to me under duress, which I received under duress. I have to tender back the money. That was not the defense in the case. Never argued. See, if they can't win the validity of the release, now they say you pay back the money. Supreme Court threw that case out in a case called Aubrey versus Energy, which they know. Now, the clerk of the court here, in the Tampa court, instead of writing a judgment and dismissing the case without prejudice, he alters and dismissed the case on the merit. By doing so, they can appeal to the appellate court. If he didn't alter, the appellate court sitting in Atlanta had no jurisdiction. You understand the trick? And the defendant's learned counsel writes a false jurisdictional statement saying that this case was decided on the merit. Who is arguing it? This slut, Annie Conway. We were given 5 minutes to argue in a packed courtroom in Atlanta. I had to fly from New York to argue this case in a predetermined panel. You understand? The panels, the members of the panel were Judge Robert Vance, who was bombed and murdered by another litigant. Second judge, Clarence Allgood. He was found dead in his bedroom with his gun. Here you hear people, 2 judges at the 11th Circuit Court of Appeal dies. One was murdered by a litigant who may have been screwed the same way I was. I was trying to do all the research. I tried to contact him in prison where he was located. I sent him a letter. They won't let me talk to him because I want to know this man is going to be executed. They won't let me speak. So eventually, all the judges in the Atlanta court, there were 26 or so at that time, they, nobody wants to take part in his trial. And they moved that to another court, I don't know where, and they found him guilty. They shot and killed him. Not shot and killed him, they gave him lethal injection. His name is Moody. Okay? Second judge, Clarence Allgood, was found in his bedroom with his gun nearby. Why an appeal court judge has to commit? Possibly, he may have disagreed with them in my case. You understand? We don't know, the man is dead. And it's a top secret. You can Google it. Clarence Allgood, Allgood, Allgood. So all top secrets, they keep it up a top secret. Maybe it will come out maybe 50 years later, after I am dead. Okay? Now, what happened was this court the clerk alters the court's order from a dismissal without prejudice into a on the merit. A panel of these three judges refuse. Okay, refuse. What they call affirm. No opinion. I raise issues. I argued the case before the panel for 5 minutes in Atlanta, 1986. I moved to the US Supreme Court because I'm not going to give up. Now, in the appeal court, the same lawyers who argued before the 11th Circuit saying that it's a final decision on the merit should be affirmed, and which was affirmed by the 11th Circuit without opinion, now argue before the Supreme Court. No, Your Honors, this is all their brief, case number 16-6168. They're arguing this is an interlocutory order, unappealable, so the Supreme Court has no jurisdiction. This is 2016. Understand, guys, girls, those who are lawyers, those who are listening to me, understand what I am saying? So they take different arguments. One argument, one court, a entirely different argument before the US Supreme Court, and Supreme Court says, yeah, the court has no jurisdiction. So, Mr. David, your writ of mandamus, writ of certiorari denied. Folks, I'm repeating the same story over and over again so that you understand. I was working in 1985, 87, somewhere in a law firm in New York. I happened to read the law journal, understand the difference between a dismissal without prejudice and a dismissal on the merit. None of the lawyers know about these two things, dismissal without prejudice. When I read this in the law journal, the difference between dismissal without prejudice and on the merit, I knew these guys have changed the things. The clerk of the court had altered. So I moved same Hodges to amend his prior order. Defendant objected to. I don't have their pleading now. But the court amended the order under Rule 60A of the Federal Rules of Civil Procedure, saying the clerk had made a grave error. You understand? So if there is an error, then they have to recall mandate. I moved the 11th Circuit under Federal Rules of Appeal Procedure 35. Federal Rules of Appeal Procedure says you can ask the court to recall mandate because the court issued a mandate. Now I am asking the court to recall because it was done through error. Now folks, under Rule 35, Federal Rules of Appeal Procedure, the case should go to a panel of 3 active judges. 3 active judges, not before a retired judge. The insiders, again, scheme it and have it before J.L. Edmondson. By the way, when I was Googling, the J.L. Edmondson was a black guy. Later on, we found out, no, this is a white guy. Okay? Regardless of his color, although I appeared before the court, argued, you don't know, they sit in the black grab and they look all alike. You don't recognize how he looks like. So, Edmondson denies. He says to me or to the clerk of the court, don't accept any papers from Mr. David on this closed file. We are telling the court, you made a grave error. So this doesn't go to a panel of 3 judges. It goes to the same judge, Edmondson, who had retired as from July 15, 2012. Right? This motion is submitted to the court 2015. So he had retired. I submit another FRA, Federal Rules of Appeal Procedure 35 motion, again paying the fee and everything. So I thought they are going to give this to a panel of 3 active judges. No, the insiders, the clerk of the court there, so understanding every court in the United States, maybe a few exceptions here and there, all deals are done by the clerk of the court with the judges. Whom you want to pick? The corporation will say, no, we don't want that judge, this judge. So it goes to the right judge of the corporation. So they deny again. You understand? It goes to, this time, before J.L. Edmondson and Marcus. Stanley Marcus is one of the judges in the Miami court when I sued the city of Miami. He did the same thing there, same tricks. But luckily for me, I appealed to the 11th Circuit at that time. I won the case. So they reversed and remanded that case. That case is failure to hire me, although I had a 98.6 score in a competitive test. They won't hire me. I don't even have a parking ticket. But evidence showed they hired people with 60 and 70 marks. Okay? So the city settled the case for around 17,000. We will show you the check. Okay? I don't fight frivolous cases. They wanted to make it look like you are a litigant. Okay? It's not my style, especially when you are looking for a job. Now, another tactics. Folks, I want everybody to listen. Another tactic is, if you fight, they will blacklist you. That's one of the strategies. So, howsoever smart, intelligent you are, howsoever qualified you are, howsoever experienced you are, nobody will hire you. You understand? Because they always want to check whoever comes to work for them. Sometimes they hire him and then later on check. Oh, they find cases, the number of cases. Oh, no, we don't want him. I happened to work for the Port Authority in New York. It was in the World Trade Center. I was on the 56th floor. We got the fastest elevators, go up to 100, whatever the floor it has then. I had the key to the room, my office room. And when they did research, I got cases against City of Miami, AT&T. They conclude erroneously, you are having some problem. They make it look like you are a bad guy. Okay? In America, tell me how many people don't even have a parking ticket. Okay? I'm not a criminal. I was cleared by the FBI when I was working for the Internal Revenue, the US Treasury. Okay? So I quit the job, it doesn't pay anything. They were paying $11,000 a year. 11,000. You understand? So that was taken up just to kill the time. Then I found out they have a bigger problem there. I can tell you, I have learned certain secrets, how they let top guys off the hook. They planted a case in my desk which belonged to a judge. I can tell who it is because I don't want to run into problem. So they got schemes all over. You think the US government is Honest? No, folks. Employers honest? No, folks. So they hire you only for their purpose. They get the cheap labor. Now they are coming to India, they have to pay the guys $2 an hour, $2. In America, they have to pay you $200 an hour. You understand? That's the difference. That's why all are coming here. I think this week, today I believe, the British Prime Minister is coming. Okay. At the time when I was living, Margaret Thatcher was the leader of opposition, and Harold Wilson was the Prime Minister during the period I lived there, 68 through 74. Okay, all my daughters were born there, 3 of them. Now, coming back to the legal issues here, folks. Now, these lawyers were playing games. I filed an appeal. The appeal went to the US Supreme Court again. Now, I had cited in my appeal brief case laws dating back to the 18th century, to the present at that time, saying that when a court lacked jurisdiction, its judgment is a nullity. You understand? I get an order, printer order, from the clerk of the court. Petition dismissed. Folks, you don't know what you get from the clerk of the court is the order of the court. You understand? Any clerk can print, put the name on the printer, put the thing, print an order, your petition denied. You don't know. There is a problem in the Supreme Court of the United States. In a given year, they only consider 80 to 100 cases. It's a discretionary. They say granting a writ of mandamus or a certiorari is a discretionary matter. So how do you get justice? US Supreme Court gets a year, on an average, 10,000 cases. 10,000. 10,000 divided on a monthly basis will be around 600 cases. Do you think these 9 men and women sitting in the US Supreme Court are going to read all the things? The brief, the opposition to the brief, or whatever it is, then reconsideration? So the task facing the US Supreme Court is enormous. What they do, as I understand, as I researched, each justice in the US Supreme Court has 5 or 6 law clerks thought to be well qualified. So they make a notation, short note, give it to the justices. So whatever kicked in their brain, this is worthy of consideration, they pick and choose. The consideration as stated in the Supreme Court rules is the questions presented. Questions presented. If the questions presented is not attractive enough, they don't go into their legal arguments because they don't have the time. So the people who make advantage is the clerk of the court. They can do things. They can fix any case before anyone they wanted. Any law clerk. You understand? This is a disease going on for the last 200-300 centuries. You understand? It's a hard research. Now, I filed another appeal to the US Supreme Court. Now, I discovered I had one of the appeals was in the name of David versus Fidelity, not AT&T, because I sued the Fidelity. I just discovered this was dated December 9, 2010, signed by Eric Fossum for William K. Souther. And this by chance I happened to get it, and I had the brief filed then, and I'm going to how the Supreme Court decided. The Supreme Court in the year 2016, in case number 9624, granted my motion for a writ of mandamus. It means the U.S. Supreme Court knew there are problems. Folks, you have to understand the name of the game going on here. India, it may take a long time, but finally the justices will hear. In America, with 9 justices, now 8, the 9th one, Ms. Jackson, has been confirmed by the Senate, so she may take office any time. One of the justices is retiring. Because they don't have to stay or they have to get out, they can stay until they die. Unlike here, judges retire at the age of 55 or 60. In India, I don't know. Okay, when our judges retire, American justices assume office and they die until they become sick, tired, or resign for personal reasons. So, the bottom line, folks, is the Supreme Court granted my writ of mandamus. Although AT&T's lawyer came and raised a counter question. Okay, they don't want to answer to the question I am raising, they are raising a counter question. Supreme Court rejected it because they know his argument has no merit. Counter question. Folks, now the new game began. After the Supreme Court of the United States granted my motion for motion for granting a writ of mandamus, the clerk of the court won't accept my petition. You understand? First clerk, a woman by the name Melissa Bladlock, she sent my papers back to me saying that there is no bank draft. I had obtained a bank draft, not a check, bank draft, pre-authorized from the ICICI Bank where I was then banking for $300. Cost me around 2 lakhs of rupees to send it to the United States. Because when I went to the post office, they said it's too heavy, you have to split it into 2. So I marked, sitting there in the post office, the main post office, MG Road, I and my assistant, at that time I think my assistant was a guy by the name Ananthu S. Nair. So we went there, we repacked, put in them, and we want to show to the clerk inside. There is not a bomb there, it's only documents. So we have to show him, and we repacked. We sent it to the guy, this woman, marking this as one of two boxes. She only opened one box. She didn't bother to open the second box, cut them into pieces, and she repacked, or her clerk or whatever it is, sent it back to me in 4 boxes, costing American taxpayer more than $500. You understand? That woman knew I have a toll-free number. I had shown my number always in the front of the brief. I had a one-age telephone at that time, which I cancelled even after I came back from USA recently. That's a toll-free number. She can call, I can call USA. They can call me from USA to here free. She didn't bother to call me. I called her several times after I got the check back from her. in the box, which he packed in 4 boxes. So I sent the check to the Chief Justice John Roberts, requesting him to assign my case a number. Understand? The clerk of the court, he is playing games. He has no interest, technically, but he is an interested person because he gets money under the table. Oh, after Chief Justice Roberts got my paper, the brief and the check, not the entire thing, 1 copy I believe I sent him. It went to clerk's office again. Now, another guy, he's a chief clerk, not chief clerk, deputy clerk. He sent it back to me again. So this guy, Jeffrey Adkins, he sent the check back to me, second time, saying that the court dismissed the case. Okay? The court's order is 5 lines long. You will see on the screen the court's order, 5-line order, which says, petition, motion to proceed in forma pauperis denied, case dismissed, unless, he doesn't want to read the sentence, unless petitioner pays the court the fee and submit the papers pursuant to the rules. That's the court's order. Unless, repeat, unless you pay the fee and submit, which I did. Now, he comes up with this argument, second argument, and which we had paid. Now he says he doesn't want to read line 3, 4, and 5, which says, unless you pay. You understand? He's not a moron. He knew the 5-line order. If he can't read English, he should not be working there in the Supreme Court of the United States. I did some research to find out who this guy is, and if my research is correct, he's somebody who used to work in the prison. He's a black guy. I don't know, he's a black or white, doesn't matter. Now, then I wrote him a letter saying that read line 3, 4, and 5. Then what he says, he raises a question, a constitutional question. The clerk of the court has no authority to raise a legal question on his own. That's why the lawyers are paid to do that. It is not the clerk's job to raise a constitutional question. This is under Article 3 of the Constitution, the court has no jurisdiction. You see, this clerk going to override the decision of the 9-justice panel who granted my motion? So I responded to him, saying that your job as a clerk of the court is to accept the papers, carry out what the court ordered you to do. You understand? Then he sends me another letter saying that read my letter dated so-and-so and Melissa Bladdock's letter. You understand? So he was playing fun here. Folks, I wrote to Chief Clerk Scott Harris. Scott Harris is a JD, Juris Doctor. He has a bachelor's, I believe, from Hastings. No, he is from Harvard, I think, a bachelor's. He can read English, right? The Supreme Court's order, he can read. 5-line order. He keeps quiet. Folks, you got to understand, the Supreme Court of the United States issues an order. Anybody, in a 5-year-old child can read that English and say what it means. He can't read, the PhD guy, the JD guy, Juris Doctor guy. So I took him to the disciplinary committee of the DC bar. You have to understand. You got to understand, folks, what's the issue in the court. Illegal termination of an employee in violation of the laws. Now you are going from one court to the other, to the other, to the other. Okay? Now, disciplinary committee of the bar doesn't give my complaint to the disciplinary council. They hush up that. They do not assign this case a number, unassigned. You are making an allegation against the clerk of the court who contumaciously refused to accept the court's order, challenging it. The little guy, the clerk, he is challenging the Supreme Court's order. Oh, so there is a whitewash in the DC circuit. Disciplinary council doesn't get it. This woman refused to accept my complaint, saying that our decision is final. She closes the file. Folks, you got to understand the way I'm traveling. Okay? Now, I go and file a complaint with the administrative courts of the United States in Washington, D.C. After several days, the case goes to a judge by the name Carl Nichols. Why there is so many days delay? The rules require the case be assigned to a judge who was picked by randomly by the computer. So what they were doing was they were trying to find out which judge will fit in their requirements. So I get a letter from the guy, Judge Nichols, Carl Nichols, who says, Mr. David, your complaint, which is 34 pages long, is too much. You have to cut down to 15 pages to explain 40 years of litigation, and that too double-spaced, not single-spaced. And he is citing Federal Rules of Civil Procedure 8. Federal Rules of Civil Procedure 8, you will see here, it says nowhere, it says short and simple. Short and simple doesn't mean 15 pages, does it? A complaint can be, an initial complaint can be any number of pages. You understand? So, Carl Nichols was wrong. He wants me to reduce my complaint to 15 pages from 34 pages. Can the court read 34 pages? And I have 200 pages of exhibits. 200 pages of exhibits. So, we were talking about what Carl Nichols, the first judge at the DC circuit, DC Columbia Court, decided based on my 34-page complaint. He ruled on his own that 34 pages complaint, as an initial complaint, filed pursuant to Rule 8 of the Federal Rules of Civil Procedure is too long. He wanted that to be reduced to 15 pages, double-spaced, to explain my 40 years of litigation. Is it possible? Well, we are attacking Carl Nichols because first it took the complaint filed on July 13th to assign to Carl Nichols, the defendant's choice, so many days. because what they were doing is, as I've seen and repeatedly can show, it's a job of shopping the judges. Which judge will rule in their favor? That's the way the things are done, always in every court in the United States. So what they do is, normally, pay money to the insiders. Insiders are those who work in the court for and on behalf of corporations to prevent the right case going to the wrong judge. So Nichols, whose picture you've seen, he ruled against me, saying that I have not shown jurisdiction, names of the parties, which was clearly shown: American Telephone and Telegraph Company, Dallas, Texas, where they were then Michigan Bell Telephone Company, 444 Michigan Avenue. Part 3 is Secretary of Labor, U.S. Department of Labor. 3, for Clerk, U.S. Supreme Court, Scott Harris, and his 2 clerks sued in their individual name and as well as in their official capacity. 5, U.S. Department of Justice, Office of the Inspector General, and Office of the Disciplinary Counsel, Hamilton Fox. So these were the 6 named parties in my complaint, and I had demanded a jury trial, as you can see here. You will see the close-up. Judge Nichols, he has the authority to do whatever he wants. He's a district judge. He ruled against me, okay, saying that I should show jurisdiction, how I am invoking the jurisdiction of the district court. As you are very well aware, the Supreme Court of the United States had already granted me permission to file a writ of mandamus in case number 16-9624, which the 2 clerks there, deputy clerks, and the chief clerk, Scott Harris, contumaciously, arbitrarily, and capriciously refused to accept. They also refused to accept a Rule 22, Supreme Court Rule 22 petition addressed to Justice Clarence Thomas, Associate Justice assigned to the 11th Circuit. So the issue before this court is what action you can take against those people. No answer. Now also you got to understand, the rules are not just framed for me alone, for the general public. And the said rules say, the local rules of the D.C. Columbia District Court, that upon presentation of a complaint, the clerk office is required to serve on all the parties where there is a pro se litigant involved. You understand? This guy doesn't want to do any of the things. I also sought my pension lying with the sucker company, AT&T, and their pension plan administrator, which amounts to at least $2 million for the last 40 years. They don't want to pay it. I sought an injunction, but he doesn't want to address that question either. So, 2 things the employer chosen judge failed to do was: A, serve the parties, which I just stated, and also refused to order the defendant to pay me my pension, to which I had contributed both as a management and non-management employee. You understand the name of the game here. Now, regardless what he did, I made an appeal to a 3-judge panel stating what this guy is saying is wrong. He is exceeding his authority because the Supreme Court had jurisdiction, that's why it issued an order. So until then, the Supreme Court got the case third time, finally, Supreme Court had jurisdiction. I don't have to prove I have jurisdiction, the court has jurisdiction in the DC Circuit, DC Columbia District Court, and the case involves a Title VII, a resigned ADEA claim. So the court has equitable jurisdiction, two types of jurisdiction. One is the original jurisdiction, second is equitable jurisdiction. I don't have to prove it. It is understood. Any judge of common sense. So he denied two grounds. A, I failed to state the basis. Two, he failed to serve all the parties required under the rules. You understand? So now I go to the another judge, another panel of judges, Judge Rao, Walker, circuit judges, and Centrally, senior circuit judge. That court's order in case number 21-5190 says, it's a 3-line order upon consideration of September 8 order to show cause, the response thereto, appellant's brief, the motion for injunction, and the motion to add additional parties. It is ordered that the order to show cause be discharged. It is further ordered that this appeal be dismissed for lack of jurisdiction. The district court's order, entered on August 5, is not a final appealable decision under 28 U.S.C. 1291. In addition, appellant has not identified any valid basis for this court to exercise jurisdiction over his interlocutory appeal. Further ordered that the motion for injunction and the motion to add additional parties be dismissed as moot. Pursuant to DC Circuit Rule 36, this disposition will not be published. The clerk is directed to withhold issuance of the mandate hearing until 7 days after resolution of any timely petition for hearing or petition for rehearing and back. See Federal Rules of Appeal Procedure 41B, DC Circuit Rule number 41, per curiam. That's the order of the 3-judge panel with regard to Judge Nichols' order. Folks, what happens? Now, as I indicated before, limiting the number of pages to 15 to people who were born and brought up abroad in various countries, that will tantamount to denial of access to the courts, because people who were coming from other countries, like myself and various others, they don't speak English or they don't write fluent English because it was not their mother tongue. In my case, my mother tongue was an Indian dialect called Malayalam. And I studied everything through up to high school through the medium of instruction Malayalam. In the college, of course, we had English, and in the law schools. So what I am trying to say, the ruling of this judge is tantamount to denial of access to the courts. And I am sure the Supreme Court of the United States is going to agree with me. Folks, I then moved to the en banc court of the United States Court of Appeals for the District of Columbia Circuit. In case number again 21-5190, and the decision was rendered on December 21, 2021. Now, there are a lot of things I wanted to tell you, but let me first say this order shown herein was before Judge Srinivasan, who is apparently an Indian gentleman, Chief Judge Henderson, Rogers, Tattle, Millett, Pillard, Wilkinson, Katsas, Rao, Walker, and Jackson, circuit judges, and Sentinel senior judge. Such judges, including the now going to be one of the associate justices of the Supreme Court, Judge Jackson. Now, this order, which is not signed, and the bottom portion of it is masked, because there is something which they don't want me to know. It can be clearly visible to the naked eye. They have stuck some piece of paper here, okay, and this order says, upon consideration of the petition for rehearing en banc and the supplement thereto, and the absence of a request by any member of the court for a roll for a vote, it is ordered that the petition be denied. So what they are saying in this so-called order, I don't see any signature, I don't see even the clerk of the court has signed it, says Mark J. Langer and Daniel Reidy, R-E-I-D-Y, deputy clerk. And there is something fishy, because I have reasons to believe the clerk of the court had done this in concert with, okay? So I don't trust anybody in the United States, because a lot of things are going on, and the poor justices, they don't know what's going on. They concentrate on the question of law, not the tricks employed by major corporations. Perhaps they may be changing my brief with their own, because I have no means to verify what was submitted by me is the one the justice is reviewing. They've got different tactics. You have to know them well, because I've gone through, I know what it is. So if this court had issued the order, which is posted to me with a 73-cent postage, which is Neo posted, Neo what they call the franking machine, which is dated 3/28/2022. That's what they are sending. You know, it's like a local mail. They think India is part of the United States. So they sent it, and I got this on what is the date here? 6/4/2022. That's April 6 actually. We do the other way, date. So I got this much later, although it had no country, nothing mentioned there. Okay, by chance, a postage with 93 paise came to India. Now, what can I do? Now I'm getting another letter. See, if the Supreme Court or the en banc court had denied my motion, which I'm sure the court may not have, I'm getting another order from another district judge. See the funny thing? One judge says, Mr. David, you don't meet the requirement. There's a what you call a per curiam order, and the Supreme Court of the not the Supreme Court, the en banc court of the DC Circuit denies that, and what I should do? I should move to the Supreme Court. I have to get a copy of this order, original order, not an email, which I never got. You understand, folks? I never got it. You don't use an email to appeal a decision of the 16-judge panel decision. Then, surprisingly, I'm getting another letter from another judge by the name Tanya Chutkan, United States District Judge. Her order is dated 28 January 2022. Now, she says in the same order, you have to do this within 30 days from the date of the order, in which plaintiff shall file an amended complaint drafted in accordance with Rule 8, 9 and 10 of the Federal Rules of Civil Procedure. Rule 5.1 of the local civil rules, which set forth all the claims he intends to bring and the defendants against whom he brings each claim, which is already there, 7 defendants. The amended complaint shall be double-spaced and presented in sequentially numbered paragraphs. Double-spaced. It shall not exceed 15 pages again, and shall not have appended thereto any document that is not essential to determination of the action. Local Rule 5.1e. If plaintiff fails to comply with the order, the court will dismiss his action without prejudice for failure to present Federal Rules of Civil 41. It is further ordered that plaintiff's motion to issue summons ECF number 7 is denied without prejudice. So what this woman is doing is exactly what Judge Nichols ordered. There is no change. But again, this order came much later. Then, and that order came to me on, that is posted with $1.30 postage, and it arrived in India on, can you read this date, please?
23/2/2022.
Okay, so it took like nearly 1 month to reach. So it was too late, right? Because what she is telling me is to do exactly what Nichols said, okay? Because there is nowhere in the rules it says the complaint should be limited to 15 pages, double spaced. You have seen the rules. So, what they are interpreting should be the standard. That's their contention. Okay, now, Chutkan's letter. Then, all of a sudden, even before I respond, I get another panel decision, 3-judge panel. Okay? First, District Judge Nichols, then Rao and the 3 judges, then the en banc court 16 judges, then another order from the Chutkan, and now finally I'm getting another order in case number 215290. This is before Judge Millett and Pillard, circuit judges, and Centenary, senior circuit judge. The order reads, in this order they have the correct address, correct state, correct country, zip code, everything correct. There's a page attached to. It says here, the date of this order is May 13, 2022. The order says, upon consideration of the petition for writ of mandamus, the motion to appoint counsel, the motion for hearing en banc, the motion to clarify, the motion to appoint counsel and for other relief, and the motion for leave to proceed in forma pauperis, it is ordered that the motion for leave to proceed in forma pauperis is granted. It is further ordered that the motion to clarify granted. As the court explained in its March 8 order, petitioner's appeal in case number 2150 was dismissed for lack of jurisdiction on November 12, 2021. Petitioner thereafter filed this court a document seeking further relief, and that document was construed as a petition for writ of mandamus and opened as a new case, number 2290. It is further ordered that the motion for hearing en banc be denied. They are saying again they denied en banc hearing. Federal Rules Appeal Procedure 35A. It is further ordered that petitioner's remaining motion be denied. In civil cases, litigants are not entitled to appointment of counsel when they have not demonstrated a sufficient likelihood of success on the merits. Petitioner has shown no basis for granting the remaining relief requested. Further ordered that the petition for writ of mandamus be denied. Petitioner has not demonstrated a clear and indisputable right to mandamus relief. See Gulfstream Aerospace versus Maya Kamas Corporation, 485 US 271 289, 1988 case. Pursuant to DC Circuit Rule 36, this disposition will not be published. Again, they don't want to publish this. Folks, this is a game contrived by the corporation's insiders, because the Supreme Court of the United States granted my petition for a writ of mandamus, and the clerk of the court won't do it. Now we are going back to the same shit, going back and forth. What is the name here? They fired an employee in violation of the laws, refused to pay him his benefits as was paid to others of similar standing in Florida and in Michigan. 1,500 people were offered 3 years' salary. I wasn't. They fired me and argued in the kangaroo courts of the United States I quit my job, which they couldn't prove. Folks, this is America. Sunil, come over here. Would you like to go and work in a country like this, where you are given a runaround by the corporations and their insiders?
No, I don't want to go America again, because from your story I have listened, it's very, you collapsed, your family collapsed, your life collapsed because of mafia corporation in America. So I don't want the similar situation in my life. So better live in India is my ambition. Thank you, sir.
Thank you, Sunil. Folks, you heard Sunil who participated. We had a lot of law students who wanted to come, and I went to 2 law schools who teach law, and at the last moment they were told don't do anything because that will affect their career. Asking questions to someone who lived nearly half a century in the United States, there is nothing to be afraid of. Nobody will come and cut your head. unless they send the mafia, of course. Folks, this is America. This is the story I want the world to understand. If we do not do something, there will be mass murders, as is happening. The other day, a kid of 18 bought a gun and killed 19 children in the 4th grade and their teachers. Maybe, we don't know at this moment because all top secrets, they don't tell. He may have the same situation for himself or members of his own family. It's all top secrets. Why the 2 judges at the 11th Circuit got murdered? Okay, Judge Robert Vance was bombed and murdered by another litigant, and the second judge was found dead in his bedroom with a gun. It's all top secret. America don't want this to be revealed to the world, because if people understand, there will be bloody revolution. Okay? So what I'm saying to you, if any of you are producers in any country, doesn't matter where you are, you may be what is called a so-called terrorist. I don't believe who are terrorists. People who resist what they are doing, they are termed as terrorists. There are no such terrorists, I don't think so, based on my experience. So if anybody wanted to make this a movie or a web series, call me, contact me. My phone number is 9656 058 330. You have to call the country code to reach India, and also you have to use the prefix 91 and followed by the number. My email address is trdavid, TRDAVID, 2009@gmail.com. Folks, if we don't do something in this country will go to dots. The Democrat-controlled Senate or the Congress now thinks they can bluff the public. I haven't got my dime from the EIP, Economic Impact Payment, passed by the Congress. Not entire payment. I got 2 payments. 3rd payment, they don't know where to send it. They have my address, they confirmed it, and they have a website to contact the IRS. It doesn't work. They have a number to call, that number doesn't work. Nothing works. I tried to file my return to get my tax, and they wanted a code, a special code. They don't use that code in India. So these people who are doing this programming, they don't know what the hell they are doing. At the moment I put my phone number 965, they convert automatically, that is an area code. What a stupid system. And who is to tell these morons what to do, how to fix their problem? They don't have people to understand where is Thiruvananthapuram, they think it is in America. Okay, that's why they put a 73 cents mail, local mail, franked mail, to send me mail, and luckily I got it. Okay? That's the kind of stupidity going on. I hope Biden administration will survive if the war ends with Russia. I don't want to dabble in politics, but the reality is all these so-called saints are not saints after all. They pretend, they lead us to believe so. American people have no faith in any of the political parties there. Okay? Thank you, ladies and gentlemen. I'm sorry to take your time, but it's time for me to correct what is going on. I may have to file another petition for writ to direct the courts below to do whatever they are required to do, or force these corporations to settle my legitimate claims. I'm not making up a story. I have a family to feed. At the time when I was dismissed illegally, my family life was shattered to pieces. And this mafia corporation paid $77 million to its outgoing president. Okay, 77 million. I haven't got 77 pence. But all my money, whatever I had, all spent on litigation. And the litigation never ends, because this F corporation is a real blood sucker. When they have no case, they prolong using the kangaroo courts of their choosing in every jurisdiction. And if this continues, we will have bloody revolution in America even before my time. We are seeing that every day. Thank you, ladies and gentlemen. I want to wish you, and I would like to have you give me a thumbs up or share, or both. Thanks.